Morning.
Morning.
Okay, ready for the first case?
SJC-13047, Commonwealth v. Roy C. Rand.
Good morning, Ms. Griffin.
Good morning. Please the court. My name is Geraldine Griffin. I represent Mr. Rand. Your Honors, the issues on appeal here today have to do with the confrontation clause. The defendant's confrontation rights were violated in this case when the Commonwealth was permitted to admit, over Mr. Rand's objection, statements made by the victim in the case in a 911 call and to responding officers at her home following the call. This error was not harmless beyond a reasonable doubt, and therefore Mr. Rand's convictions should be reversed. In this case, Your Honors, the victim of this domestic incident was unavailable. She had asserted her Fifth Amendment right not to testify. As you are aware, when a victim or any witness is unavailable.
Counsel, can I stop you for a minute? You're referring to this as a domestic incident. Wasn't she strangled and knocked unconscious and strangled to the point where she urinated and had severe facial swelling? It's not really an incident, is it?
I suppose that's fair to say. It was domestic report of a domestic assault.
Okay, thank you.
As Your Honors are aware, when a witness is unavailable and the defendant has had no prior opportunity to cross-examine the witness, the court must go through a two-step process before admitting her hearsay statements. The first is whether the statements fit within an exception to the hearsay rule, and the second is whether the statements are testimonial. In this case, the statements were arguably excited utterances. However, they were testimonial, so did not satisfy the second portion of the test. The test that the court is to apply is the primary purpose test from Davis versus Washington. That test states that statements are only non-testimonial if, within the context of police questioning, if the police questioning, the primary purpose for the police questioning was to resolve an ongoing emergency. And there are a number of factors that come into play there.
Counsel, if I could interrupt you on this one. There were two sets that you're talking about. You're talking about the 911 and you're also talking about the statements that were made to the police that responded on scene. Let's start with the 911 transmission. When do you contend the question and answer between the dispatcher and the caller went from non-testimonial to testimonial? Is there a line of demarcation that you can point us to and say it was when the dispatcher asked this question and elicited these answers that it went from testimonial to?
Yes, Your Honor. I would contend that it's at line 12 where the dispatcher has asked her, are you there right now with him? And she says, no, he left. At this point, and if you look at the case law, it's very clear. If a defendant has left the scene and there is no longer any danger or apparent danger to the victim, that is the line when it starts to become looking more testimonial.
Now, what do you say about Justice Seifer's first point to you, though? This was an arguably savage beating, and there are all types of other things that are emergency aside from whether or not the perpetrator might still be there, like if they need a medical response. So how is the person, the dispatcher, supposed to inform what to respond with without asking questions to elicit that type of information?
Well, first of all, the dispatcher can ask whatever she wants. This is not a case about what dispatchers can ask and can't ask. This is a question about what can be admitted where the defendant has had no prior opportunity to cross-examine that witness. So the dispatcher can ask her whatever she wants.
But it's two-part. It's not only what the dispatcher asks, it's also what the person responds.
Yes.
So to the extent that we're also talking about what she responds with what happens, if that's used to inform what the response ought to be, why is that testimonial?
If there were questions and answers having to do with determining the need for medical care and the degree to which the person was injured, that's one thing, I agree. The dispatcher does not ask anything about the victim's medical condition until almost halfway through the call. It's on the second.
Counsel, I assumed you've listened to the tape, right? So you know the victim is pretty much unable to answer many questions and pretty much hysterical, or crying or in pain. So what kind of questions, what should a dispatcher do in those circumstances? Are there a prescribed set of questions they should ask that would differentiate that? What exactly did the dispatcher do that you say we should not be admitted? And is it the question or the answer you're arguing with?
The dispatcher didn't do anything wrong, but I'm saying that now, when we're talking about whether these are testimonial or not, we have to look at the call and objectively discern whether the operator reasonably believed that there was an ongoing emergency. The only way we can do that is by looking at this conversation. This operator, and I did listen to the tape, and the victim, I would challenge the description of her being hysterical. She is
Okay,
clearly
that's
upset.
fair.
She's crying.
Hysterical is the wrong word. You're right.
Very quietly talking, hard to understand because she's crying. Dispatcher can ask whatever she wants, but we need to discern whether the operator reasonably believed there was an ongoing emergency. The operator does not ask her about her medical condition until many, many lines into this call. The operator is concerned with finding out who the boyfriend is and where he is from.
Ms.
I
Griffin,
am not blaming her for that.
Ms.
but
Griffin, if I could
of course.
interrupt you for a moment. You recognize in your brief at one point, as has this court for, 7 years now, that an ongoing emergency is a factor, perhaps even the most important factor, in determining whether or not a statement is testimonial. It is not the be-all and end-all. The test is not whether the primary purpose of the interrogation is to respond to an ongoing emergency. That is not the test. The test is whether the primary purpose, looking at all the circumstances, is whether or not this would constitute a substitute for trial testimony. In fact, in Michigan versus Bryant, we learn that we, of course, look at what the interrogator says, but ultimately it's from the perspective of the out-of-court declarant. Now, it doesn't take long listening to that tape. And by the way, Sergeant Yee describes her as hysterical, but it doesn't take long listening to that tape to think that the primary purpose of this victim statement of the police is not to create a substitute for trial testimony. And what I'd really want to hone in on here is beyond the 911 call, this is an incredibly unique situation because she's still on the phone when the police come, sort of not even cognizant that the police are there. And we actually, from the 911 call, have a feel for what it was like during the conversation with the police. So when you apply the test that the United States Supreme Court used, that we've used for many years now, where does the lack of formality, the nature of the out-of-court declarant's attitude and presentation indicate that this is testimonial?
Well, first of all, Your Honor, I would push back a little bit on your assessment of the importance of the ongoing emergency. In Davis versus Washington, they specifically state that in order for, and this is again, the Commonwealth's burden to prove it's non-testimonial. They state that a statement is non-testimonial when the primary purpose is to resolve or to meet or address an ongoing
That's basically what we said in Gonzalez too. It's just that the law's changed since Davis versus
In
Washington.
Beatrice, Your Honor, in Beatrice, this court said, in order for there to be non-testimonial statements, there must be, the primary purpose must be, there must be an ongoing emergency.
And we've said that's not the case so many times now since Beatrice. It's come up in
I
Wordsworth,
disagree.
it's come
I
up in
disagree, Your Honor.
McGeehan.
I
Sure.
disagree. I disagree.
Well, what about this? We've said many, many times that cognate provisions of the Declaration of Rights do not provide enhanced constitutional protections when dealing with the confrontation clause other than in the face-to-face circumstances or in the Tasomi DNA testing circumstances. So the doctrine that we're applying, in addition to all our cases talking about the primary purpose is to create a substitute for trial testimony, our cases look to Michigan versus Bryant. Your brief recognizes that the test you're arguing is not the law.
I disagree. I have to disagree, Your Honor. And even in Michigan versus Bryant, the whole focus of the analysis in that case is on the danger that is being posed by the armed perpetrator whose
Justice
location
Sotomayor
is
talks
unknown.
about the formality and lack of formality, and the line is something like, an emergency is a factor, perhaps even the most important factor, but it is a factor.
Okay, well, we can talk about the other factors. if you
Well,
want to.
I just don't understand. You disagree with what? You disagree that the primary purpose is only to respond to an ongoing emergency?
I think that's what the case law shows. If you look at the facts of all of the cases from this court and on the Supreme Court on this issue, the focus is on the ongoing emergency and
But
the
when you
danger
say,
that
but
is
when you
posed.
say that's the test, and that's what the Supreme Court says, how do you reconcile that with the Supreme Court saying that's not the test?
Well-
That ongoing emergency is a factor, the most important factor, but the test is whether the primary purpose is to create a substitute for trial testimony. I don't understand how you can just change the test.
I don't think I'm changing the test. I'm using the test. I understand that the broader issue is are they trying to create out-of-court testimony? That is the broader issue. But in looking at that in the context of 911 calls and officers responding to the scene, they look at, is there a threat to the victim? Is there a threat to the officers? Is there a threat to the public, such that we can say that in this situation, the police are not acting as investigators. They're acting to resolve the threat, whether that is a defendant is still on the scene, like in Beatrice or in Galicia or in Davis. In Davis and Galicia, in fact, the court is very persuaded by the fact that the assault is actually still happening while the victim is on the phone. In Beatrice, the assault has just ended, but the defendant is in the next apartment over. And that's a huge part of the reasoning of the case. So my point is that there is this focus on what is happening at the moment. That's why the word ongoing is so important. Is the defendant armed? Is the defendant still at the scene? And in this situation we have here, the defendant has left. The operator clearly believes the
But
victim.
how do we know? I mean, hindsight's always easy, right? So we've got her report, and again, she's shaken at a minimum, and she says he's left with her sister, which suggests they're going to come back, right? Or at least there's some concern that they're going to return, right? Because that's one of the reasons they're asking about the car, right? What car is he driving? Right? That's part of the phone call with the dispatcher. What car is he driving? How is he left? Because the police are coming there, and it's fluid, right?
Well, Your Honor, I have to completely disagree.
Go ahead. That's your
The
job.
fact that he left, this is entirely speculative. She said he left.
Well, no, because you're assuming he's left and gone forever. She said he's left with her sister, and the dispatcher goes, "What car is he driving?" Because the police are going to obviously want to know if he's in the vicinity, right? Because
Or they want to pick him up.
Well, or they want to make sure if he's there, they know he's there, so they're not surprised, right?
The fact that he may have come back, we can, of course, that's a possibility, but
Well, but that's what I'm talking about, is that there's uncertainty here. And that's why I'm trying to get back to Justice George's question about where the line of demarcation is. Because I think you have a loser on the dispatcher, but at some point the police have moved into an investigatory mode, and I'm trying to figure out when. But I don't
I would
believe,
argue,
I
I
know
would argue
you believe everything, even the call. I don't know why she's staying on the phone, why she's sending an ambulance, why she's, asking questions about the person, unless the dispatcher is concerned there's an ongoing emergency. And this
Well,
doesn't seem like a defendant a victim who's setting up somebody. She's frightened and shaken at a minimum. But
well, the dispatcher, if I may, the dispatcher doesn't even relay the defendant's name to the responding officers.
yes, she does.
I do not believe that she does, Your Honor.
Well, she asked for
relays the address and the apartment number.
As the boyfriend. Well, yeah, of course, but I'm saying that if they're so concerned about Mr. Rand and that he may have a record or he may be a violent person,
Aren't
the
aren't
case
they
law,
concerned because they're responding to what is a domestic incident or a domestic altercation, and those are very dangerous for police officers. So there's concern about that. We're getting so into the details of what the police and what the dispatcher were thinking, when really isn't our focus on the victim at this point and how she's preparing her test, what she's saying? The focus isn't on the question, should it be? It should be on the responses.
well, it's
And
both,
whether
Your
the
Honor.
victim thinks or the target of the violence thinks that she's preparing something for trial.
It's both, Your Honor.
Both?
And part of the problem is that police officers act as first responders. So they have oftentimes mixed motives. But that's why we have to look at what happened in this case to try to discern what they were thinking. The officers in this case did not even look through the apartment to see if Mr. Rand was still there. There is no concern about a volatile scene, that they may be attacked. There's no threat that he's going to return. I would urge you to look at the case law. There is consistently, if the defendant has left the scene and there's no risk to return, he's not armed, there is no speculating going on that, oh, he might come back. The only time that comes up even marginally is in Beatrice, and that's because the defendant is in the next apartment over and the caller uses the present tense to say, please come right now. He is packing his stuff. Please come before he leaves. Every other case, if the defendant has left, the emergency has ended.
So
Okay,
you want us to adopt a categorical rule that if someone calls a dispatcher and says the defendant has left, the emergency is over? No matter what?
If there are no other circumstances to which you can look that say he made a threat to return. There's even a case, I think it's Wilson, where the guy did threaten to return. He said, I'll be back in 15 minutes to kill you. It was still testimonial in that case. That was on-scene questioning. But in that case, they still said it was testimonial because the scene was secure. There was no threat at that point. So I would just urge you to look at the precedent and compare it to the facts of this case. Thank you, Your Honors.
thank you.
Thank you.
Okay, Attorney Monahan.
May it please the court, Assistant District Attorney Megan Monahan on behalf of the Commonwealth. It's important in this case to consider the circumstances that the victim was facing, as pretty much talked about already this morning. It's 12:45 at night. She has just been severely beaten by her boyfriend, strangled to the point that she has lost consciousness twice, and she has lost control of her bladder. She's calling 911, asking, please, somebody come to my house. She is alone with her 3-year-old daughter. The defendant has just left moments earlier with her sister. We don't know, the victim doesn't know whether he's going to return, whether he's outside the door, just outside the property, around the block. It is a volatile.
Counsel, can you articulate a proper test for us?
Yes, Your Honor. The test would be whether the primary purpose of the victim's statements were an out-of-court substitute. And that would be considering many factors, including the surrounding circumstances, the primary purpose of the interrogator's questioning, the primary purpose of or the motives of the victim's statements, or a reasonable person in the victim's place, because this is an objective inquiry. The formality of the interview, and whether there is an existing ongoing emergency.
Can I ask you Justice George's question? Because I agree with you on the 911 call, but the police, how many police show up there? He's not there. Aren't we in the investigatory mode very quickly and testimonial mode once the police show up there and he's not there and they've secured the scene?
Your Honor, so 2 officers arrived, Sergeant Yee and Officer Connolly, and they arrived within minutes of the 911 call, within minutes of the attack. And yes, investigators, police officers have dual roles. They have a caretaking function, and as well as they are investigators. So there are mixed motives. And you can see that at times in the testimony when the officers say, we were there to see what happened, and we were also there to see if the victim was okay. We were there because of medical welfare to see the series of events. So the Commonwealth acknowledges there's mixed motives, but what's important for determining whether a statement the victim gave to the officers is the specific questioning and the officer's concerns at that moment. Because if we look at the specific questions, I would urge the court that this is a concern of a medical emergency. Sergeant Yee says what happened, and the victim provides an incredibly high level statement. She says just, I was punched in the face, elbowed in the face, and choked. And I believe maybe hit in the face a couple times, but it was that very high level. And Sergeant Yee hears choked. And his response is, when you say choked, what does that mean? And she puts her hands to her neck. And then he follows up and says, did you lose consciousness? Yes. Did you lose control of your bladder? Yes. Those questions are assessing the seriousness of her injuries, particularly where strangulation injuries, there is a concern that the victim's airways could close at any moment. And so those are the—
Attorney Monahan, if you don't mind, I'd like to interrupt you with one question.
Yes.
The concern that I have, and this goes back to your opposing counsel's point, Officer Yee, for whatever he's asking, he's not a medical provider. So whether it's I have a headache, I have a sprain, or the more specific things that he was being told, he's going to call an ambulance. He's not going to administer aid. He's not going to start giving treatment. So whether it's the most benign complaint or the most serious description, the response is going to be the same. I'm going to call an ambulance. So all of those questions, aren't those investigatory and not really toward addressing any kind of medical emergency? Because the response is going to be the same. He's not a doctor. He's not a paramedic.
Your Honor, no, I would suggest in the circumstances, if we just change, because hindsight is 20/20, so let's change the factual scenario where prior to the paramedics arriving, her airways did close up and she lost consciousness. Sergeant Yee would have had to report to the paramedics what she said. So it was imperative on the officers arriving to understand the extent of her injuries where there was a concern of losing consciousness or trouble breathing, so that he can then relay it to the paramedics. But just because the victim did not lose consciousness here, did not have trouble breathing, that doesn't negate the motives of the officers questioning at that time.
Thank you.
You're welcome. Thank you.
Ms. Monahan, isn't the truth? First of all, you are right. Michigan versus Bryan talks about the perspective of the interrogator being a factor in ultimately determining what we need to determine, which is from the perspective of the out-of-court declarant, objectively speaking, reasonable out-of-court declarant would the primary purpose be for the purposes of creating a substitute for trial testimony. But the reality is, as Justice Georges was just addressing, the reality is that the police are there with mixed motives. They do not walk to that front door saying, okay, I am going to compartmentalize my mind and do no investigation. I am not going to think about a prosecution. The reality is that there's mixed motives. And it well may be that even the victim here, as upset as we hear her on the 911 call, may even have mixed motives as well. And I think it's, sort of if you listen and think about this whole thing, unrealistic to think the police don't have some aspect of investigation in mind. But that's not dispositive.
No, and I acknowledge that likely there are mixed motives. You can see that in the general testimony of the officers when they say, we're there to see what happened, but we're there to see if she's okay, if she needs medical attention. So if we were going to take it then from the victim's perspective of what at that point is she saying, a reasonable person in her shoes, again, she has just been severely beaten. She has asked for help. She's in fear. She's afraid to even leave the apartment. And a reasonable person in her perspective at that point is just looking for help. It's just looking for the resolve these injuries, to understand what's going on. And so cannot say that a reasonable person in her shoes would expect that her statements at that moment were going to be used as an out-of-court substitute for testimony. Now, when we get to say the ambulance in the hospital, where she provides a very detailed account of what happened, including that the attack started in the bathroom and then she was dragged to the bedroom, where she then provides the order of the injuries, that's where I think a reasonable person would start expecting that these statements are being used for building a case against the defendant.
That's where Judge Brassard, he was a very careful, excellent trial judge. That's where he drew the line, isn't it?
Yes, so the judge drew the line at, Justice Brassard drew the line at them leaving the apartment in the ambulance. I would even say, Your Honor, that all of those statements that we've been discussing, that the officers inquired whether the injuries and the loss of consciousness, urination, those statements all came either before or as the paramedics arrived, and there wasn't much conversation as the paramedics were treating. So we can even draw that line a little closer to the medical attention.
Well, let's take the defendant, take the appellant's point here, which is, you've got the defendant left. I think the testimony might have been something like a couple of minutes before the 911 call, and the police arrive while they're still on the phone within a number of minutes. But the police are there at that moment, and she's going to be taken away in an ambulance. So if an emergency means that the defendant's going to come back and threaten the victim and the police, that could always be true. So, emergency is not the be end all. Matter of fact, in Michigan versus Bryan, it says Davis should not be taken to imply that the existence or non-existence of an ongoing emergency is dispositive of the testimonial inquiry. But nonetheless, it's an important factor, absolutely. And here, at least in the sense of the imminent threat from the defendant to the police officers and to the victim, is that really paramount right at that moment?
At the moment that the officers have arrived, and I believe it was Sergeant Yee's testimony that he stepped only a few feet in because he was not sure what he was entering into, but it was a small apartment. And so I would say at that point, the scene does appear secure. And unless the defendant returned, it was secure during that questioning. But really at that point, the purpose of the questioning was medical, looking at those specific questions. And again, the victim providing a very high level account of what happened, really just explaining the officers her injuries so that she could have medical attention. That is why those statements are non-testimonial or would not be expected to be used as an out-of-court substitute. But yes, the volatile scene is really paramount in the 911 call, but then the police do secure the scene.
The appeals court cuts it off much earlier. So where do they err? Can you sort of point out where their mistakes are in their analysis?
Yes. So there's a few points here, and I'll take it in turn of the 911 call and then to the officers. For the 911 call, I've had this trouble in preparing for our argument. You look at these statements on the piece of paper, and it's easy to sort of look at them in a vacuum and parse, what is this, what is that? And the appeals courts application appears to have just focused on whether the question was eliciting past details, but that really took it out of the context of the ongoing emergency and what would have been the victim or a reasonable person in the victim's perspective. And so parsing that 911 call and going back and forth from testimonial to non-testimonial, at least in these circumstances, did not make sense, where the victim was presented with this ongoing emergency of just having been severely beaten and the defendant could return at any moment.
I get that with the 911. How about the police? Because I find that much harder.
So with the police here, in applying in Beatrice, the appeals court ended its inquiry at there's no ongoing emergency, so then we don't engage in any other of the analysis or factors in Michigan v. Bryant. And the Commonwealth would urge that there was an ongoing emergency and that their primary purpose was for medical attention. But it was also an incredibly informal interview. The officers didn't get a lot of detail from that. It was very high level, as I've explained. And so even looking at the other factors in this inquiry, a reasonable person in that perspective of the victim would not expect her statements to be used as out-of-court substitute. So, and to the point where also Beatrice, I would suggest, does not apply in this case. In Beatrice, this court found that there was no longer an ongoing emergency because when the defendant had left or police secured the scene. But there wasn't evidence there of
Beatrice is the opposite. Beatrice is the opposite. Beatrice, he's next door, so they do have an ongoing emergency.
I apologize. Yes, so the inquiry was, I think, that if the defendant had left or police arrived, then the emergency ended. It was almost a hypothetical, I think, in Beatrice. But what we have here is this medical emergency and the strangulation to the point of losing consciousness twice and having lost control.
But can I push you on that a little bit? Because I mean, I understand they learn that this is more serious than what it appears when they first get there, because she's bruised, right? But she's not bleeding, and it's not obvious that this has been this dramatic an assault on her, right? Until there's all the follow-up questioning about that she loses consciousness, right?
I would push back a little bit.
When they get there, she looks stable, right? She's not bleeding. I take it she's upright. So, and they're waiting for the ambulance, and as Justice George said, these guys aren't doctors, nor are they EMTs. So I guess, isn't even the medical issue relatively stable at some point?
I would push back and say that there was observable injuries to her face. There was swelling and bruising. Officer Connolly saw red marks and bruising to the neck. Sergeant Yee saw blood-like veins, petechial hemorrhaging in the eyes, and the soiled pants was observable. So there was corroborating evidence to those statements that this was a severe beating. And so there had to be an assessment of how severe at that point. And to the point, if I may just briefly touch upon the issue of preservation of the objections in this case, particularly as we're talking about the officer's testimony, I think it's very important to consider the issues separately, where 911 call, Sergeant Yee's testimony, and Officer Connolly's testimony all have a little bit of a different procedural issue. And what's significant about the officer's testimony is that how it played out over the course of the 2 days pre-trial, the motion in limine hearing and the voir dire hearing. At the motion in limine, the trial counsel, when asked the opportunity to discuss the officer's testimony and his objections, said, we need to have a voir dire. We need to know where these statements come from. We need to know if they're observations or response in question, which is absolutely right. And then at the voir dire, after the officer's testimony, Justice Broussard indicates his findings, but says, I would be glad to hear from you, counsel, on any objections. And at that point, trial counsel does not object. Trial counsel actually asks to elicit more testimony, which is allowed without objection. And so then we get to the trial, and Sergeant Yee testifies without objection. Under those circumstances, that should not be considered preserved and should be reviewed for a substantial risk of miscarriage of justice. And then when we get to Officer Connolly's testimony, at trial counsel says, objection just for the record, which again would not with the background of the voir dire, doesn't do a specific objection or arguments. And even if it would be considered preserved, Officer Connolly reviewed under harmless error, it is harmless because it's repetitive of Sergeant Yee, who testified first and was without objection. The only 2 points that was brought up on Officer Connolly's testimony on direct that was not Sergeant Yee's was one, that she had been elbowed in the face, which was harmless because the jury was deadlocked on that charge and it was no pros. The second point was that the sister slapped the victim in the face 3 times, pointing to another assailant. That doesn't prejudice the defendant. So to the extent that there is question about the officer's testimony, it was harmless beyond a reasonable doubt, and Sergeant Yee's testimony was substantial risk of miscarriage of justice. If there are no further,
Thank you.
thank you.
Thanks so much.
Thank you. Commonwealth Press on brief. Thank you.